We will go on the record in the matter 25 CF 27, State of Wisconsin versus James Langer. The state appears through Assistant District Attorney Jose Villard in person. We have Daniel Chapman, Defense Counsel in person. We also have Mr. Langer in person in custody. We're set today in this matter for a sentencing portion of this case. Mr. Langer pled guilty to count 3, possession with intent, methamphetamine greater than 10 grams, but less than 50 grams on or near a youth center. So with that modifier, he pled guilty on June 4th, 2025. The court ordered a pre-sentence investigation report. The court has reviewed the report, and out of my review, I do not believe anything jumped out at this court as a material issue that needs to be addressed on the record. Mr. Villard, did you receive a copy of the PSI?
Yes, Your Honor, I did.
And you reviewed that?
Yes, Your Honor.
Any corrections or modifications of the material nature that should be stated on the record?
Your Honor, the only correction I would note is that in the breakdown of the prior record for Mr. Langer, of the offense date of May 16, 2007, there seems to be some confusion about the offenses that were actually listed. Looks like count 1 was actually aiding and abetting possessing chemical agents with intent to manufacture meth. Count 2 was causing or permitting a child or vulnerable adult to ingest, inhale, be exposed to meth.
I'm just going to ask you to slow
My
down.
bad. Count 2 was causing or permitting a child or vulnerable adult to ingest, inhale, or be exposed to meth. Count 3 was terroristic threats. Of those 3 counts, he was convicted of count 2, Your Honor.
All right. Okay. Other than that, no material corrections or modifications?
No, Your Honor.
This is what is listed.
And while Mr. Chapman is talking with Mr. Langer,
What was count 2 again that he was convicted of?
The causing or permitting a child or vulnerable adult to ingest, inhale, or be exposed to methamphetamine.
all right, Mr. Villard.
Okay.
I don't know if you, I can't recall if you argued something of this degree in front of the court. I just want to remind you to slow down
Understood, Your Honor.
so that the court reporter can take everything down accurately. Mr. Chapman, did you receive a copy of the PSI
I did, Your Honor.
and you reviewed it thoroughly?
Yes, I did.
And you did so with Mr. Langer?
Yes.
Did you have any material corrections or modifications for the record?
The only thing that Mr. Langer wanted to note is that he recalls his treatment history differently. The agent says that in 2022, he was referred to follow-up outpatient treatment at North Star Regional. He recalls North Star Regional being only an inpatient treatment facility. He does not recall any outpatient after that. I'm sure the agent had records that she was looking at, but Mr. Langer's recollection differs.
Okay, thank you. Mr. Villard, I will now turn to you for your argument and sentencing recommendation, please.
Thank you, Your Honor. The DOC currently recommends 7.5 to 9 years initial confinement and 3 to 4 years extended supervision. The state's recommendation will be for 9 years total, broken down as 6 years initial confinement, 3 years extended supervision, eligible for programming after 3 years of initial confinement.
Can you repeat that? You went a little fast and I'm
Nope,
not used
sorry
to it
about
being
that.
spit out right away.
Understood. So once more, the DOC recommends 7.5 to 9 years initial
9.5,
confinement.
actually.
Oh, my apologies. And 3 to 4 years extended supervision. The state's recommendation will be for 9 years total, broken down as 6 years initial confinement and 3 years extended supervision with eligibility for programming after 3 years of actual initial confinement. When looking at the offense and the read-in charges, it indicates that this is not a case of simple possession, but rather an indication of individual that maintained a drug trafficking place. The quantities of the drugs, namely the 34.3 grams of methamphetamine and paraphernalia gathered, further reinforce that fact. The goals of this sentence should center on rehabilitation and deterrence. When looking at Mr. Langer's history, it paints a clear picture as to why the sentence cannot be probation. Mr. Langer was sentenced in Minnesota in 2015 for possession of narcotics. As a result, he spent the following 9 years on probation. During that time, he repeatedly violated conditions of probation by continuously testing positive for meth, failing to report for probation, and on numerous occasions, attempting to falsify drug tests. Despite various stints in jail and admissions to various inpatient treatment centers, during that time, Mr. Langer continued to use methamphetamines. Since all these events occurred while Mr. Langer was on probation, the next consideration must be jail. In this case, jail would also not be an appropriate answer for the gravity of the offense that Mr. Langer committed. Jail cannot be the solution when such a large amount of methamphetamine is being sold less than 250 feet away from a youth center. Any jail sentence would work against the idea of generally deterring drug dealing. We must then look to incapacitation. As detailed in the PSI, Mr. Langer not only refuses to accept responsibility for his actions, but he rationalizes those actions to minimize the seriousness of the offense that he was only selling methamphetamines to support his personal habit. This is more than just sustaining a personal drug habit, but rather a repeated history of engaging in dangerous behavior. For instance, on page 11 of the PSI report, Mr. Langer recounted his version of events as they relate to the charges he received in May of 2007 for terroristic threats, aiding and abetting manufacturing of methamphetamine, and causing or permitting a child or vulnerable adult to ingest, inhale, or be exposed to meth. In that section of the report, Mr. Langer explained that there was a dude coming to his garage and making methamphetamine. His girlfriend at the time had a child that had access to that garage, but he claims that she only turned him into law enforcement because she thought he was cheating on her. According to Mr. Langer, he was leaving the building and his then girlfriend was screaming at him from the third-story window of said building. And Mr. Langer, in response, told her he was going to slit her throat and pull out her tongue so she could not report him to the police. This has certainly caused for great concern. Mr. Langer is willing to resort to such violence so quickly to protect criminal activity. In this instance, the manufacture of methamphetamine. The PSI also describes Mr. Langer's long history of drug abuse. While he was previously on probation, Mr. Langer simply could not follow the directions of his probation agent, nor the conditions of his probation generally. To his credit, Mr. Langer went to inpatient treatment. He did weekly meetings with the DOC agent. However, he still continued to test positive for meth use and failed to report once again on numerous occasions. As such, he needs treatment in a confined setting. Given Mr. Langer's current jail credit, the court should structure this sentence in a manner that ensures that Mr. Langer actually sits in prison for a moderate amount of time before actually becoming eligible for any programming. Since he does not have any prior drug dealing convictions, I'm recommending a sentence close to the range provided by the PSI writer. I do not believe the max sentence here is appropriate, seeing how Mr. Langer does not have a past conviction for drug dealing. The max sentence should be reserved for those individuals. Ultimately, this defendant should have a prison sentence of 9 years total, comprised of 6 years of initial confinement, followed by 3 years of extended supervision. A moderate prison sentence can serve as future deterrence for Mr. Langer's criminal thinking. His refusal to accept responsibility and minimize the seriousness of this offense further justifies the structure of that sentence. The need for real-time prison, enough time to reflect before being provided the opportunity to actually conduct any programming to help attack his substance abuse issue. Thank you.
Thank you. Mr. Chapman, argument and sentencing recommendation, please.
Well, Judge, I'm glad the state and I generally agree that the recommendation from the department appeared to be a bit out of scale from what we normally see for possession with intent to deliver of 10 to 50 grams. I believe that a prison sentence for that offense is usually in the range of 4 to 6 years. And the state's recommendation is essentially at the high end of what I've seen in the past for that sort of thing. I don't know exactly why the agent was calling for such a lengthy prison sentence in this case. I suspect it had to do with frustration over how Mr. Langer has done on supervision in the past. But That's an argument against probation, not really an argument for a longer prison sentence. And to be honest, I don't have a lot of experience with the youth center aspect of this case. But I would point out that the youth center in question was not actually involved in any of Mr. Langer's behavior. It's just a geographic fact of where his house is. He wasn't dealing to patrons of the youth center. He wasn't, people from his house weren't using on the grounds and leaving drug paraphernalia on the youth center. There was really nothing connecting it except the fact that his house happens to be within a range of it. So the case involved possession of 43 grams of methamphetamine, and leading up to the warrant, there were 2 sales to the same undercover buyer. Mr. Langer has been to prison in the past. He does have a lengthy criminal history, although most of that started in 2007. I think a lot of his convictions listed in the PSI are driving offenses. And his probation has not gone well in the past. But I would point out that most of the problems listed in the PSI with probation in the past all come from that period during COVID-19, where I don't think Minnesota supervision was even having much of a conversation with Mr. Langer, much less actually supervising him. Call the court's attention to the couple of instances where the agent details trying to have a hold placed and jails saying, well, we're not going to take him right now. It's kind of hard to kick meth in general. But when there are literally no consequences for you continuing to use, I'm sorry, but the probation was ineffective during that period of time. There is reason to believe that probation could be more effective now, especially considering Mr. Langer is asking the court to consider drug court as an option. He has already spoken to Ms. Anderson. He's done the application. She gave me an email that I've submitted to the court and shown the district attorney, which shows that I believe he would be a good candidate for drug court if the court would consider it. I'd ask the court to consider imposing and staying a substantial prison sentence, such as the 6 years the state is asking for, and can use some length of conditional jail time. Despite sentence credit, the court still has up to a year available, although I would think holding some as a penalty for drug court might be appropriate. And supervise Mr. Langer here in Burnett County and actually monitor the areas of concern that I think were allowed to skate on previous areas of supervision. I think that there are mental health concerns here. I'd note Mr. Langer in the PSI suffers from anxiety, depression, bipolar disorder, PTSD, and ADHD. He's been using methamphetamine for a very long time and was exposed to older people who were manufacturing methamphetamine when he was still a young teenager. It's a difficult drug to stop using, and Mr. Langer has been using it for a very long time. He does, to his credit, actually maintain employment, and although the agent uses that as a mark against him because he should have money, why is he still selling? I don't believe that necessarily means you can support a substantial methamphetamine habit just because he happens to have a job. And that doesn't mean that he was not a user. The agent seems to imply that because he was employed, he must simply be selling for cash. And I don't think the evidence supports that. Mr. Langer clearly has a long-standing addiction. And for what it's worth, I think he was being completely honest with the PSI author that he does need that extra income in order to actually maintain his own habit. He's not out getting rich selling methamphetamine. You can tell that by his lifestyle. I do think the fact that he's consistently employed shows that he does have the ambition to actually want to live a normal life. And it's going to take more of an effort that he's put forward in the past. However, I do believe that treatment court can maintain accountability in a level that hasn't been tried before. And there is a possibility that Mr. Langer will be able to live a law-abiding lifestyle without having to send him to prison at this time. That's all, Judge.
All right, thank you. Mr. Langer, did you give me an amount of your recommendation?
I didn't put a specific number on the probation, Judge, but I did suggest that imposing and staying the sentence that the state requested.
Okay. All right, Mr. Langer, I'm now going to give you an opportunity to make any statement you wish to the court. You don't have to, but it's your only time to let me know if you've heard anything that you may want to elaborate on, or you want to correct, or anything that you want me to know and to consider before I sentence you, okay?
The only thing I'd like to say is that I do take full accountability for what I did. And I would like to apologize to the community and to my family, to everybody involved for my actions. I know they're wrong and I'm truly sorry for it. I really just am very sorry for my actions. I believe that the short-term treatments just were, not, I learned very many skills, but it was just a dry out period. 30-day program is just, it didn't, I'm not blaming the treatment centers, but it just didn't help me very much. But I would very much like to try drug court. I believe it would hold me accountable. I've heard good and bad things about the program, but I have 100% faith in myself that I could, with that help, stay sober and give back to the community.
All right, thank you. Mr. Langer, you've been in front of the court before, you've been in front of this court, you've been in front of other courts, so you know what the courts need to look at with regards to sentencing, but I'm required to go over that with you again. In sentencing, a judge has to look at certain factors and certain things. The first is the nature and gravity of the offense. How serious is this crime? How serious are your actions and your conduct? Then I have to look at your character. That includes your criminal history. It includes all of the information that's contained in this packet right here, okay? Which I have reviewed. This pre-sentence investigation report I have reviewed at least twice. And I've made my notations from what I've reviewed and what I can see. The third thing is I have to look at needing to protect the public, all right? And that means either if there are specific victims or the community as a whole. Other factors that I need to look at are if you have any rehabilitative needs, if you have the ability to rehabilitate, if you have any undesirable behavior patterns. If I can look at your history and say, okay, he has a pattern here, it's really undesirable. Your culpability, your age, your education. And I also have to look at deterrence. I have to look at specific deterrence and general deterrence. Specific deterrence is I need to look at this matter and come up with a sentence that should deter you from committing similar crimes or crimes of this nature, okay? I also have to look at general deterrence, that is deterring others from engaging in this type of criminal conduct and doing what you did, okay? Here, I have listened to the arguments of both counsel and I've heard your statement. And I've reviewed this pre-sentence investigation report. You have admitted to a very serious crime. It's more than just possession of methamphetamine. This is possession with intent. That means you had the intent to deliver, to sell, to engage in that type of conduct with others or to others. You specifically, you made that conscious choice to engage in this conduct. You also were facing, in this case, other very serious allegations and charges. Another manufacturing and delivering of amphetamine, methamphetamine, less than 3 grams near a youth center. Another charge of manufacturing, delivering amphetamine, methamphetamine under 3 grams with a modifier of near a youth center, maintaining a drug trafficking place, and possession of narcotic drugs. That one was as a party to a crime, but party to a crime means you engaged in that crime in some way, shape, or form. During the plea, the court went over its colloquy with you and dismissed and read ends, and your attorney went over that with you in the fact that the court can look at those charges when determining a sentence, okay? You can't be sentenced more than the maximum possible penalty for the crime you pled guilty to, but the other crimes can come into play. Those other charges can. Now, when we look at this case and we look at what you were originally charged with, and if the court calculates this, I come up with 57 years of prison hanging over your head. If you went to a jury and the jury found you guilty of each of these charges, 57 years of prison. Most of it in custody in prison, other out as extended supervision. And with the Class D felony that you pled guilty to, it does have the modifier, that limits your exposure to 25 years of incarceration, either with 15 years in and 10 years out. With the modifier, that states that the court can, with the confinement portion, increase it an additional 5 years if the court finds it to be appropriate. So essentially, you face a lot of time in prison with the charge you pled guilty to. You got a heck of a deal. Because if the court were to sentence you to the total amount of prison, if you were convicted and found guilty of those charges, essentially it could mean that you would die in prison, or when you are released, you'll be very old. So you got a good deal with this agreement. I have different recommendations here, 3 completely different recommendations, all right, for this serious crime. I have the recommendation from the Department of Corrections, 7.5 to 9.5 years of initial confinement with 3 to 4 years of extended supervision. I have the state's recommendation for 6 years of initial confinement, 3 years of extended supervision. And then I have the defense's recommendation of some amount of probation, whatever the court determines to be appropriate, with an imposed and stayed sentence of 6 years of initial confinement, 3 years of extended supervision. 3 very different recommendations. I have reviewed the PSI, and from reviewing the PSI, it does note that from a very early age, you've had a lot of trauma in your life. You've had close people die of suicide, I believe also in a car accident, those things that can significantly impact a person's mental health. You also started using substances at a pretty early age. And I'm not sure if that was your way of addressing, of self-medicating the issues that you have, plus the diagnoses that you have of the ADHD, the anxiety, those type of things. Or if it was to be recreational. "13 years old. You were 13 years old when you first used methamphetamine. That scares me a lot. For a couple reasons. A 13-year-old should not even be around methamphetamine, should not even know what methamphetamine is. You should be playing baseball or running track or, in some type of youth activity, you were experimenting and using and consuming methamphetamine. It also scares me and brings concern that you were 13 years old when you first started using the methamphetamine. How old are you?
49, Your Honor.
49. You're 49 years old. So that means that you've been using methamphetamine for 36 years. That's a long stretch. So in 36 years, you've been unable to figure out how to be sober and how to not engage in criminal conduct. It's instilled in you since you were 13 years old. When you were 13 years old, you have the benefit of the doubt. As you're a child, you didn't know any better. And it appears to me you didn't have the adults in your life to direct you at a positive way to go, or to help you when they see you struggling in using substances. At 36 years old, to be using methamphetamine is a long time. When I look at this case and the seriousness of it, every single person in here, I can't guarantee, but I'm pretty sure, believes that this is a serious, serious crime, engaging in the sale and distribution of methamphetamine. And there were 2 confidential buys there. So you had 2 people coming, or 1 person, or the CI was 1 person, but you had 2 times that you engaged in a sale of methamphetamine. The court's history and statistics all would tend to show that's not your first time you sold. And plus, in the PSI, you admit to selling illegal substances. You admit, and you say, I had a hefty habit. I needed to sell, essentially, you said, to support your habit, to support your use of methamphetamine. With this matter and the seriousness of it, the court has to look at the fact that you were engaging and participating in the sale of a very dangerous, poisonous, and addictive drug to members of the community. And you were affecting more people than I believe you even thought about. Because you are affecting not simply the 1 person you sold to, you are affecting their family, you are affecting their friends, you are affecting their community. You are essentially part of a destruction and devastation to your community, to the county. Again, making it more serious. Here, you admit you're not just a user and an addict or someone with a substance abuse disorder, but you are a dealer, you are a seller of this poison. You became part of the problem. Hopefully with some rehabilitation and some cognitive thinking, you will be able to get out of that criminal thinking mindset, and you will be able to follow rules of supervision, and you will be able to contribute to society and be a member of the community in a positive way. That's what the court can hope. And looking at your character and your rehabilitative prospects, I see that you have them. I hear that you want to do more. You want to engage in more in-depth treatment. You want to be in the drug court because you believe that'll be strict and that will hold you accountable. You have had a significant amount of years of substance abuse disorders. When I look at your criminal history, you have a lengthy criminal history going back to juvenile, but going back to at least 1996. I didn't count exactly how many convictions there were, but it filled 3 pages. That's a lot of convictions. A positive is that, as Mr. Chapman said, you continue to be employed. You work and you go to your job and you do the things that, I don't want to say normal people do, healthy people do. Or what we should strive to do. Problem is that you not only were working, but then you had your side job of selling. And one of the things that the court needs to look at is that needing to protect the public. And here, in a case like this is protecting the community as a whole. And the people who live in this community, which include the people that you've sold methamphetamine to and their families, because they've all suffered and they've all been impacted in a tangential way. So I need to consider protecting the public with the general deterrence, the specific deterrence, or other ways to ensure that the public is not going to be further impacted by your conduct and your criminal thinking. Mr. Chapman's argument for probation is one that I have to first consider, because my higher courts tell me that I need to consider probation first, unless confinement is necessary to protect the public from further criminal activity from you, unless you need correctional treatment, meaning you need to be incarcerated to receive that type of treatment because you've not been able to get that treatment, or you've not availed yourself of that treatment in the public, in the community, or it just hasn't hit you hard enough to engage in that treatment and to follow the path. If the court orders confinement, incarceration, the court must look at the minimum amount, which is consistent with those factors, with the protection of the public, the gravity of the offense, and your rehabilitative needs. The issue here and what the court sees is that this isn't the first time you've admitted to selling and engaging in dealing methamphetamine for a significant amount of time. You weren't just caught on these 2 CI buys, or you were caught on these 2 buys, but you've stated that you have engaged in this multiple times and you just didn't get caught. I hear you and I want to believe you in the fact that you want to change your life. You want to do things differently. And you now have said that since you've been incarcerated, you've had a change of view, a change of a way of thinking, and a change in your personality and your mentality. You have said that in the past, when you felt disrespected or you felt that someone was doing wrong to you, your first instinct was to punch them or engage in physical contact. But you claim now that you're incarcerated, that that's changed, and you have a better way of thinking. I don't know how that's changed. I don't know if you've taken classes. I don't know if you've engaged in any type of programs. I don't know any of those things. I just know what I have read and what you have said. I do hear remorse in your statement today, and I do feel and hear the remorse in the information you provided to the PSI author. It says that you felt horrible, you feel bad, especially then finding out that this was a learning center where kids and other youths are. You didn't realize that that's where you were located and what you were doing and the impact that that has. So I do see the remorse. I don't quite understand something that you said. I understand that you want to be in drug court, you want to be on probation, you want to have the oversight, you want to engage in programming. But what I don't understand is a statement that you made to the PSI author in which you would like the judge to throw, or you would like the judge not to throw you in prison. And then you said it would not help you and you would just get out early on ERP. ERP is a substance abuse program. It's a program designed to rehabilitate inmates, to teach them about the things that you learn going through drug court or any other treatment program. You know that, and you're shaking your head up and down. So I just didn't understand the statement. It would not help you and you would just get out early on ERP. The main focus here in a sentence like this, which would be intent to deliver methamphetamine, the main focus that I see in a case like this is the seriousness and gravity of the offense and protecting the public. I know you may not see ERP as something that can help you or assist you, and it's just a way to get out of prison early. But it's a program that was designed to help inmates, to help rehabilitate inmates. You've been given an opportunity many times with regards to probation. I fully understand what Mr. Chapman said. When I read what happened when you were on probation and the facts, I laughed out loud. When it says you were taken into custody on violation and you admitted to methamphetamine use and the jail wouldn't take you, and this was on November 3rd, 2022. The jail wouldn't take you, but you were given a strong verbal warning that you needed to comply with probation. Absurd. That is literally absurd. You should have been taken into custody. Probation in Minnesota is quite different than probation in Wisconsin, and I would agree with that. Sometimes probation in Minnesota could be 25 years and you never talk to your agent, maybe once a year or something. And having probation on Zoom, pretty silly. You need to see the people. You need to look at all of their actions, their conduct, the way their eyes twitch, the way their mouth moves when they talk, the way their eyes roam. In person is the only way that you get a true idea of how a person is doing. Anyone can say on Zoom, yep, I'm clean. I've been doing all that I need to do. I've been working on myself and I'm doing great. When perhaps you're really not. but it's hard to tell when you're on Zoom. You've asked to be considered for drug court. And I have read the email or information from Ms. Anderson where she did say that you would be a good candidate for drug court based upon the high risk factors, not upon what you're convicted of. That doesn't come into play until later. It's just whether or not you meet criteria to be eligible in the first step. Second step is looking at the charge. Okay. I'm going to tell you it's rare in Burnett County, at least, for the drug court to accept dealers and people who engage in selling of drugs. I can't say it hasn't ever happened. I'm not quite sure on that statistic, but it rarely happens. And there's a reason, because you're not just a user. You can look at people who use illegal substances, and I know that there's been arguments that the legislature had made the laws or try and prohibit or to enforce people in not using illegal substances. But when I look at people who are simply users, people who simply have a substance abuse issue and disorder, those are people with a mental health disorder. You are not only a person with a substance abuse disorder, you are a criminal. And I'm not looking at your past criminal conduct to say that. You are a criminal because you engaged in the sale and delivery of methamphetamine. And you were shaking your head up and down.
I agree with you.
So you understand and you agree. And that's the issue that I have in reviewing this case. I'm going to tell you, I've had other people in front of me for similar charges and similar things. And the court has to look at the individual person in front of me. In some cases, there were people that have sold far more or have different connections and bring a lot more of illegal substances into the county. I didn't see that with you. I don't know because I don't have an investigation and I don't have anyone telling me otherwise. So I'm just going to take it as I'm recommended or has been argued to me that you're not a high-end dealer. Okay, I don't know for sure. I don't know anything, but I'm not going to put upon you a heavier sentence simply because you sold methamphetamine. Because I don't have any other connection that you've done anything more serious, or you're bringing in 1,000 grams of methamphetamine every month, or engaging in all of these sales. And I'm going to tell you, it doesn't matter if you're living in poverty, selling methamphetamine, or you're living a life of luxury, you're still selling methamphetamine. So in review of this case, again, my highest thing is the seriousness of the offense and the protection of the community. So when I'm looking at this matter, what I am going to do is I am going to sentence you to 6 years of initial confinement with 6 years of extended supervision. I am going to give you the ability to do ERP. I'm going to tell you in cases with dealers intent to deliver, I don't do this often. But I am going to give you the ability to engage in ERP when you have 2 years left on your sentence. That's because I hear from you, Mr. Langer, and I see from you, Mr. Langer, that you do have trauma, you do have issues, and I want to believe you really want to be sober. You really want to lead a life of good instead of bad. So that's why I'm saying you can engage in the substance abuse program. You're aged out for the challenge incarceration program. Now, when you are on extended supervision, you're going to have certain conditions that you must follow: absolute sobriety, no alcohol, no illegal substances, no paraphernalia, no medications without prescription, regular drug testing, to complete any and all programs that the DOC, Department of Corrections, recommends. I'm also ordering, like, Thinking for a Change or Breaking Barriers or some type of program like that, because I believe, Mr. Langer, that, and again, you started so early, so I can't blame you from the beginning. It's so instilled in you. The criminal thinking is so in you that you need help trying to realize what is better to do and how to do it better, and to have some self-reflection. And when you are out, another condition would be gainful employment and no contact with anyone on felony drug probation or felony drug extended supervision unless approved by your agent. How many days of credit?
I have 188, not including today.
188 days of jail credit, $518 in fines and fees. You will no longer be able to use or possess a firearm for life. No voting in any election until your civil rights are restored. I'm ordering you to provide your DNA. In a charge like this and a conviction like this, I don't believe you will be able to expunge it, but you can still try and write a written letter to the Department of Justice, not to this court, to the Department of Justice. And you can do that. Failing to pay your fines and fees, the court will enter a civil judgment against you and could issue a warrant. You could sit up to 6 months in jail. I believe that's covered. I've covered everything. Mr. Villard, what am I missing?
Nothing for mine, Your Honor.
Mr. Chapman, what am I missing?
I can't think of anything either.
All right. Thank you. Then we are adjourned.
Wait, I gotta grab a piece of paper.
Did I say your appeal, 20 days to appeal? Should you fail to appeal within 20 days, you lose that right?
Can't remember if you did or not, but I'll be explaining that right now.
All right, so I'm going to go back on the record and just tell you, you have 20 days to appeal. Should you fail to appeal within 20 days, you lose that right. Now we're adjourned. Thank you.